Thank you very much for joining our webinar on judicial lawmaking in European constitutional courts. I'm very happy to welcome you on here in Krakow, but also in the cities and countries where you're staying at the moment. As you know, my name is Monika Florczak-Wątor, and I'm a director of the Center for Interdisciplinary Constitutional Studies. And this webinar is organized by our center, together with the Faculty of Law and Administration of the Jagiellonian University and the Central and Eastern European chapter of the International Society of Public Law, so ICON-S. I have a great pleasure and honor to welcome you on behalf of our center, but also I have been asked to kindly welcome you on behalf of two co-chairs of the chapter, Professor David Kosar and Professor Eszter Bodnar, who could not join us at the moment. As we have with us the Dean of the Faculty of Law and Administration of the Jagiellonian University, Professor Jerzy Pisuliński, I would like to kindly ask him to provide his welcoming remarks on behalf of the faculty. Professor, the screen is yours, and please remember to turn on the microphone.
So good afternoon, everybody, ladies and gentlemen. It's my great pleasure to welcome you at the university. However, we cannot meet face-to-face in Krakow, but there are some benefits because of this kind of communication. So thanks to this meeting through internet, we can meet from different countries, so we have probably more participants than we can meet. We can have if this conference would take place in Krakow. Secondly, this is a good opportunity to meet, and we can see our faces without masks. So this also benefits. Thanks this kind of communication. This conference is organized by the Center for Interdisciplinary Studies, Constitutional Studies, in order to discuss the methodology and outcome of the research which was found in a book, Judicial Law-Making in European Constitutional Courts, published in last year. So we have co-editors of this book. Monika Florczak-Wątor is one of the co-editors of this book. So the topic of this conference is very challenging and very current. Yesterday, the Polish Constitutional Tribunal published a justification of one of the judgment, which was awarded in October 2020. And this is a good example how the functions of the Constitutional Tribunal change in current time. So this judgment was about the pregnancy termination, and this problem was discussed in the parliament, but the parliament couldn't adopt a law which could change the statutory regulation on this topic. And 15 judges of the Constitutional Tribunal replaced the parliament. So this is the problem, whether the Constitutional Tribunal may play such a function, and what the border is of the creation of the norm through the jurisdiction, through the jurisprudence of the constitutional tribunals. So there are the new functions of the Constitutional Tribunal, particularly in Poland, arise different legal problems. So I think that this conference would be a good occasion for discussion the new problems arising from the jurisprudence of the constitutional courts and tribunals. And also it would be a good occasion for discussion different theoretical problems, to what extent the constitutional courts or tribunals may create new norms. Whether such norms could be changed, and in which way by the parliament. So those questions, in my opinion, I'm not a specialist in constitutional law, but in my opinion, those questions are very interesting, and I want to wish you very interesting discussion and fruitful outcomes of this discussion. So I think that this conference would be one of the several conferences which will take place perhaps face-to-face in Krakow or other countries concerning those problems. So again, I wish you pleasant, interesting conference, and I would like to invite you to Krakow when the pandemic would be over. Thank you for your attention.
Thank you so much, Professor Piasuniecki, for your welcoming remarks. And now, without undue delay, we can go to the first panel, which is devoted to the lawmaking activity of the Central and Eastern European Constitutional Courts. So I'm very pleased to introduce the chair of this panel, Professor Frosina Gordos-Orosz, sorry for my pronunciation of the surname, the director of the Institute for Legal Studies at Hungarian Academy of Science. So thank you, Frosina, for accepting the invitation, and please take the screen for sharing.
Thank you. Thank you very much for the introduction, Monika. And a preliminary remark that it's so funny that we have been working together for so long, and still it's very difficult to pronounce the names, because for us the Slavic names are difficult to pronounce, and for you it's always the Hungarian names difficult to pronounce. But I'm sure that we will manage it sooner or later perfectly. I really hope that we will also perfectly manage to discover the lawmaking activity of constitutional courts and other high courts in Europe and also around the world, because as the question raising of the whole book and of this project is extremely challenging, I'm sure that to analyze and to qualify the answers given by the authors of this book and then given by scholarship examining this problem are also very very interesting. So in this first panel, we will focus, as Monika already mentioned, on the Central and East European courts and their jurisprudence. And the first qualification, the first analysis that we will hear is the analysis of Professor Martin Belov, an old friend of mine from the Sofia University, Bulgaria, who is also dealing with comparative constitutional law for a long time. So I'm pretty sure that when he talks about the Bulgarian case, he recognizes and takes into consideration the whole global context of this problem, knowing very well the operation of other courts too. So Martin, thank you for being with us now, and the floor is yours.
Köszönöm, Fruzi. That's thank you in Hungarian, right? Okay, I would like to thank Monika for inviting me both to contribute with a chapter. to the book, as well as to participate in this event. And I'm really happy to see so many smart people talking about a topic which is not only topical, but really fundamental for at least the last 10 to 20 years, and will be of huge importance also for the future. So I would try to be brief, and usually the people are afraid when they hear that somebody will be brief, because then you have something like 40-minute speech. But if you know me, you know. Yes, so I already have like 12, and I will try to be fast and furious as usual. And actually, I can be fast because the Bulgarian Constitutional Court has already 30 years of tradition, which is not that long, but also I can be furious because there are some issues that can be briefly outlined, and they're really problematic. So maybe you would like to have a very brief introduction about the design of the Constitutional Court. I know that that can be a bit boring because that's a comparative information that everybody can read. But still, I would like to tell you that actually Bulgaria didn't have experience with constitutional control until the last constitution adopted in 1991. And the court was again created in 1991 and started functioning 1 year later. Previously, we had some very meager and fragile theoretical suggestions for introduction of something like constitutional control in our first constitution before World War II, but they were not taken seriously. And then during communism, the concept of constitutional court and constitutional control was, of course, not compatible with the logic of the Soviet type democracy. As you all know, the Polish Constitutional Court was the first that actually emerged in that part of the world. And there were also some discussions in the Bulgarian legal literature in the last months before the fall of the Berlin Wall. Having said that, the Bulgarian Constitutional Court was a great novelty, and it was met with huge interest. And during the last 30 years, it has developed a rather extensive practice, unfortunately not related so much to human rights. But so if you want an initial label, what is the Bulgarian Constitutional Court? You know that comparative classification and division of the courts, of the constitutional courts, into state courts and human rights courts. So in that regard, you can say that, for example, the Bundesverfassungsgericht, the German Constitutional Court, is very much a human rights court, last but not least because of its extensive practice on the Verfassungsbeschwerde, on the constitutional complaint. But the Bulgarian Constitutional Court is something like the opposite. So it has a lot of important decisions. It has contributed a lot to the development of the Bulgarian constitutional order, but there is a rather scarce case law on human rights, and there is an important reason for that. Namely, there is very limited access to constitutional justice in Bulgaria, which means that there is neither actio popularis nor individual constitutional complaint, and there is rather limited mediated way to approach the court when it comes to human rights. You can do that via the ombudsman, a little bit resembling the Spanish amparo, but very, very broadly. And then recently, the Supreme Bar Council can do that as well. And of course, in the case of if you have a pending case in front of the courts, you have some very indirect access to the Constitutional Court, which I can discuss later if you're interested. But actually, it's a great rarity for a court, for a Bulgarian court, different from the Supreme Administrative Court and the Supreme Court of Cassation, to try to approach the Constitutional Court, last but not least, because that court, of lower instance, should go through the filter of the Supreme Court. So that judge has to approach first the Supreme Court of Cassation or the Supreme Administrative Court, depending on what kind of court is that, and then these two supreme instances may eventually bring the case to the Constitutional Court. In contrast to what I have said about human rights, the Bulgarian Constitutional Court has rather imperial catalog of competences, which means that it, of course, accomplishes norm control, abstract control for constitutionality, and some limited options for concrete control. It solves disputes for separation of powers and competences, but it has a very imperial tool, namely the tool for abstract interpretation of the Constitution. Right, so there are actually two main devices by virtue of which the Bulgarian Constitutional Court became a central player, not only when it comes to protection of the Constitution or international law, but also when it comes to further development of the Bulgarian constitutional model, including the Bulgarian Constitution, which means that I can boldly say that the Bulgarian Constitutional Court is indeed a lawmaker. And as you can see, as you will see in the remaining 7 minutes or something, Frozi will tell me when I have to shut up, you will see that the Bulgarian Constitutional Court has evolved from a court which was modeled on predominantly Kelsenian types of constitutional jurisdictions into a positive legislator, right? Because actually the founding fathers and mothers of the Bulgarian Constitution of 1991 have deliberately chosen, I would say, one main and three additional models for adoption of models for constitutional control. All of them were, of course, continental centralized type ex posteriori control for constitutionality. But the main model was Italy, for many reasons. I can discuss them if you're interested. Italy was in general rather inspirational constitutional model for us at the initial phase, I would say. It's not a traditionally huge source of inspiration, but when the constitution was adopted, the judiciary and the constitutional court was very much influenced by the Italian constitutional model, and then also Austria, to a lesser extent Germany, and to some extent Spain. So these were the four main constitutional courts which were kind of followed. And the Italian Constitutional Court and of course the Austrian are known to be initially constructed as Kelsenian courts. And as we all know, the initial model that Kelsen proposed was the model of the negative legislator. Of course, this model has later on evolved in all these jurisdictions, but actually the Bulgarian Constitutional Court did that with a great speed, with a great expediency for less than 30 years. And just to give you a few examples, the Bulgarian Constitutional Court is, I can say, both negative and positive legislator. And it's both negative ordinary legislator and negative and positive constitutional legislator. It's negative ordinary legislator because it can invalidate provisions which are contained in the Acts of Parliament, and the Constitutional Court itself defines that not as abolition of acts, not as invalidation, but the court prefers to use the formula that these provisions cease to apply, shall not be applied, right? But as we all know, there are no semi-pregnant people and no semi-dead people, so there are also no semi-valid norms. And one of the main characteristics of the legal norm is that they're either valid or not. So if you invalidate norms, this means that you de facto abolish them, right? But in general, what I'm saying is very heretical. So I will be most probably burned on the, with torches, because the Bulgarian doctrine prefers to use this politically correct formula that the norm is not abolished, but it ceases to apply, in order not to challenge the parliamento-centric traditions that we have. The Bulgarian Constitutional Court has also the occasion to perform as a negative constitutional legislator, because here I don't have much time to elaborate that thought, but you know, the concept of constitutional polymorphism, and the Bulgarian constitution belongs to that model, which means that we have something like a core, constitutional core, which is not defined in terms of identity. It is not defined. It is not an amendable clause, but it's entrenched clause, because it contains some provisions which should be amended only by virtue of the Grand National Assembly, which is a special covenant. And then the rest, the remaining provisions, can be amended, of course, with qualified majorities and so on and so forth, with enhanced procedural hurdles by the parliament. So this division of the constituent power and the procedures by virtue of which it is accomplished allows the Constitutional Court to control the constitutionality of constitutional amendments. So we know that very topical issue. We have a lot of recent books published, for example, by Richard Albert, Yaniv Rosna, and many others. So we have one case of unconstitutional constitutional amendment in the Bulgarian case, which was declared unconstitutional. So that constitutional law was struck down by the court, and the court actually has empowered itself a couple of years earlier to do that. So that's a clear example of negative constitutional legislation performed by the court. And then going upwards to the positive, going to the more problematic zone, so to say, of the performance of the Constitutional Court as a positive legislator. Actually, the Bulgarian Constitutional Court can be pointed out if you speak Bulgarian, or if you read the very few texts published on it, some of which are my product, so to say. It can be quoted as a clear example of judicial activism. And it's really a powerful activist jurisdiction, although I am not sure if the court itself perceives as such. So it's a kind of strange, I think the court has many times overstepped the division between legislation and jurisdiction, you know, and control, but it tries to be modest. So I'm not absolutely sure whether the judges really understand how activist they are. I can give you a few examples if you're interested a bit later. So how does the Bulgarian Constitutional Court function as a positive legislator? First, through this abstract interpretation of the Constitution, right? That's like the paradise for judicial activism, you know? You can be asked, for example, to define what is rule of law, and then you can write brand new constitution. Or if you're asked what is the republic, then you can actually create a new constitution of yourself. So, so that's a very powerful tool. Of course, the court has to be approached by the institutions that can do that. Of course, it's bound to the question, but if the question is, what is rule of law, according to the Bulgarian constitution, or what is included in the form of governance, then this is really the Pandora box for activism. And then another way for the court to be activist, which is used very extensively, is in the course of its controlling activity, because the Bulgarian Constitutional Court can control whether the acts of parliament and some other acts are in compliance with the constitution and with the international treaties. It controls the constitutionality of the international treaties with the constitution, and so on and so forth. And that's what the court does. It uses very frequently teleological interpretation, implying goals that have to be achieved. It uses massively extensive interpretation of texts, and I will just give you brief examples if I have like 5 minutes, Fruji. Yeah, one minute. Okay, and then I'm jumping to the examples, which should be instead of a conclusion. So you may wonder whether the regulation of the national parliament is what is the status of the regulation, and there was a huge theoretical discussion. What is it? The court pronounced in 2010 that it has a legal the status of an act of parliament. Before that, it was not clear. There are provisions which say that the sending of military troops of the Bulgarian army abroad, or the receipt of foreign troops on the Bulgarian territory, should be done on the basis of decision of the national parliament. But then there were two decisions of the court which say that if there is a broad decision of the parliament, then all other agreements, the number of the troops, their deployments, and so on and so forth, can be done by the government, right? So you can never read that in the text. That sense comes from the decision of the court. And that's another very interesting pronouncement on that topic. The Bulgarian Constitutional Court said that the military troops of military allies, which belong to a common defense organization like NATO, for example, are not foreign troops. So if you really agree with that, for example, the Turkish army can't really enter Bulgarian territory because it's not foreign troops, according to the Constitutional Court. Just one final example, because it's really important. There were 3 decisions of the Constitutional Court adopted in the pre-accession period, so in the last years before Bulgaria joined the European Union in 2007. These were decisions 3 of 2003, 3 of 2004, and 8 of 2005. And these were very important, powerful decisions, because the Constitutional Court was asked which parts of the Bulgarian Constitution can be amended by the Grand National Assembly and which of them can be amended by the Parliament. So this was one of the fundamental questions. How do you accomplish constituent power, especially related to EU integration? So in the first decision in 2003, the court said that almost everything that should be amended in the Constitution must be amended by this special covenant, which meant that even if you kind of introduce a very small amendment in the competences, which kind of reflect the institutional balance, that's again a matter which should be solved by the Grand National Assembly because it concerns the form of governance. So the form of governance was not limited to the parliamentary republic, but it went much further. Less than 1 year later, in 2004, less than 1 year later, the Constitutional Court has adopted the opposite decision, saying that, for example, saying some strange things, that, for example, the transfer of competences towards the European Union or the huge reform in the judicial power do not concern the form of governance, and they can be done by the Parliament. Because the court realized what it has done and that it has actually prevented the Bulgarian accession to the European Union. So it's kind of changed this opinion, but it was this decision 3 of 2004, which is politically very correct, and I support it very much, is legally rather wrong because it's not only activist, but also it changes, it produces unpredictability of the court's practice, right? And one last very interesting thing, which I'm going to finish, just to give you that example. In that decision 3 of 2004, the court says that the form of territorial distribution of power, so the fact, the question whether Bulgaria is unitary state, federation, or whatever, concerns only the power levels below the national level. So if you want to transform Bulgaria from unitary state into federation, you have to summon Grand National Assembly. But the changes upwards above the national level do not concern the form of territorial distribution of power. So if somebody decides to create new Yugoslavia and Bulgaria has to join it, then you don't need Grand National Assembly, which is, I think, a kind of absurd decision. Of course, the Constitutional Court has also contributed a lot to the development of the Bulgarian model in a very positive way. It has adjusted the Constitution to the challenges of the social and political life. But in both cases, I have, of course, exposed some paradoxical decisions, but there are also many positive decisions. But in both cases, we can clearly say that the Bulgarian court performs the function of both negative and positive legislator. Thank you very much for your attention.
Thank you very, very much, Martin. And we already have 3 notions from Martin's presentation that might be able to be starting points. I hope you can hear me.
Yes.
So maybe these can be starting points for the further discussion, because actually Martin was talking first about competence issues, then about activism issues, and lastly about interpretation issues. So I could group the arguments into these 3 categories that might give frames to further assessments as well. But let's listen to Jan Malír's presentation now. Jan is from the Czech Republic, from our fellow institute, so the Institute for Legal Studies of the Czech Academy of Sciences. Jan, the floor is yours.
So, Fruzina, thank you very much for the floor. Like Martin, before embarking on work, first of all, I would like to express my gratitude to Monika Florczak-Wątor and her institute, or her center, for organizing this very interesting webinar, but especially for organizing this challenging project, which I had the opportunity to join. Actually, I'm going to start where Monika has finished in the book, which we have contributed to. So I will try to share my presentation. Just a small minute. In her conclusions, hopefully you can see that.
Yes, yes, we can.
So, no, that's perfect. I apologize. In her conclusions, Monika writes that constitutional courts, or most constitutional courts, no longer fall within the framework of the concept of the negative lawmaker as described by Hans Kelsen. And she also emphasizes that constitutional courts today correct, supplement, and develop the wording of statutes. And very often, they also indicate to parliaments the need to change the law. Actually, these conclusions are perfectly applicable to the Czech Constitutional Court. And in my contribution, I would like to demonstrate the correctness of these conclusions. So to start with, the Czech Constitutional Court has been obviously designed as a negative lawmaker in the Czech Constitution. It's also the impact of Czech constitutional tradition. Moreover, especially in the last 2 decades, the Constitutional Court has adopted a rather restrained posture. Repeatedly, it has even ruled that self-restraint is the leading principle which judicial review shall be built on. In spite of these facts, being constructed as negative lawmaker and being linked to or giving importance to judicial self-restraint, the Czech Constitutional Court has repeatedly read in, out or down words, notions and principles into Czech constitutional law, but also to ordinary infra-constitutional Czech law. And in this way, in the last 3 decades, the Constitutional Court of the Czech Republic has substantially co-shaped constitutional and legal system of the Czech Republic, but also the political system. And viewed from this perspective, the term of judicial lawmaking, or perhaps a bit more archaic term of judicial legislation, is fully justified in the Czech context. The fact that the Czech Constitutional Court legislates, judicial legislates, is obviously linked to many factors, and we could definitely go through them for a long time. So just briefly to mention some which I personally consider as important. It is necessary to mention 3 things, or 3 aspects which are clearly legal. Primarily, the Czech Constitutional Court possesses wide powers of judicial review. So firstly, it is judicial review of legislation, but also the power to resolve constitutional complaints, which can be also linked to motions to review legislation. And finally, the Constitutional Court is attributed the power to review treaties a priori before their ratification. Apart from this fact, there are very few textual limits on the exercise of these powers in the Constitution. Secondly, under Article 89 of the Czech Constitution, some of the decisions of the Constitutional Court are expressly deemed to be binding on all bodies and persons. Also, this provision has been subject to numerous discussions since 1993, when the court came into being. The consensus is on the fact that enforceable decisions, judgments of the court, are generally binding and are being attributed rather wide legal effects. Thirdly, apart from exercising the powers of judicial review, the Czech Constitutional Court is also empowered to exercise powers of justice politique, as the French colleague would call that, like impeachment, for example, impeachment procedures. And this factor is quite important, in my opinion, because it raises political sensibility to Constitutional Court, and even politicians have to take the Constitutional Court seriously. Apart from these factors which are legal, when it comes to judicial legislation by the Constitutional Court, obviously extra-legal factors must be mentioned as well. And in this regard, firstly, we have to speak about the impact of constitutional tradition. Especially Czechoslovak Federal Constitutional Court, although it existed only for a very short time at the beginning of 1990, had rather wide powers of judicial review, plus the express power to provide an interpretation of the acts of the Federal Parliament, and also the power to recommend improvements of legislation where it was needed. And secondly, obviously, when the Czech Constitutional Court came into being in 1990s, that was the period of profound political, economic, and social change linked to the fall of communism. And that definitely created a wide space and wide expectations towards constitutional adjudication in general. So with these factors in mind, let's have a look at some prominent examples of judicial legislation by the Czech Constitutional Court. Primarily, the Czech Constitutional Court on some occasions fills in the gaps which exist in the Constitution, and also in the course of time, it develops the Constitution as the living instrument. So, for example, in 2018, we had an interesting case concerning the powers of the president to grant a general pardon or amnesty. And the issue was whether the general pardon can be granted on a condition, and whether the president can decide whether the condition was met or not. And the Constitution was completely silent, or still is completely silent on the issue. And it was the Constitutional Court which actually filled in this gap by deciding that general pardon can be granted on condition by the president. However, it is not the president who has the power to decide whether a condition was met, but that this power is vested only in the judiciary, ordinary judiciary. So an example of a hardcore gap which existed and which was filled in by interpretation of constitutional principles. The Czech Constitutional Court also legislates when it identifies the core values which the Czech Constitution and political system is based on. And in this process of identifying the core values, the court keeps the grip on the process of constitutional amendment in the Czech Republic, and also on some notable political acts. So when speaking about this form of judicial legislation, obviously the Melchák Doctrine of 2009 must be mentioned. It was actually the very first case where the Constitutional Court was confronted with the issue of constitutional amendment, and by identifying the core values of the Constitution, the court reached the conclusion that the amendment in issue conflicted with the essential features of the democratic rule of law state, and struck down the amendment in issue. Since then, we haven't had any other comparable example, but interestingly, last year, the Constitutional Court somewhat revived this doctrine when it was confronted with a challenge against the declaration of a state of emergency, closely linked to the COVID pandemic. And in this case, also the court ruled the declaration of a state of emergency itself is a political question that cannot be normally judicially scrutinized. It said that if such a declaration conflicted with the essential features of the democratic rule of law state, judicial review by the Constitutional Court could be possible. Thirdly, the Czech Constitutional Court also legislates when it prescribes either negative or positive standards of conduct with respect to constitutional actors in circumstances where these standards are not clear or are not defined in a precise way. By way of example, in 2013, the court decided a banal but important case in which it dealt with the internal procedure of the Chamber of Deputies. In a case where when a group of opposition MPs challenged the practice of taking a vote and holding a session after 9 p.m. When under the rules of procedure of the Chamber of Deputies, normally a session shall be closed by 9 p.m. The court actually entered the debate and reached a conclusion that in situations where the House approves by resolution that the time of the session, duration of the session can be extended, such practice is possible under the existing constitutional rules. Then obviously the Czech Constitutional Court often provides constitution consistent interpretation of ordinary law. And in this way, very often it unifies how provisions of ordinary law shall be understood and applied in the Czech jurisdiction. So again, by way of example, in June 2020, the court extended the right to response under the Press Act to internet versions of journals and newspapers, which are not normally covered by the Press Act, arguing by constitutional values. It simply extended the right to response even to these internet mutations of journals and newspapers. And when it comes to legislation by the Czech Constitutional Court, obviously, in the Czech Republic, we have also the practice of interpretative judgments or interpretative verdicts, and also judgments which modify the scope of application of legal rules. Apart from these situations when the court legislates in a direct way, there is also plenty of situations in which the court legislates indirectly. And in this regard, definitely and probably the most frequent form of judicial legislation that can be found in the practice of the Czech Constitutional Court, these are the situations when the court makes open statements on the quality of the existing law and also on the necessity of legal change, of legal amendment, which often leads to addressing specific guidelines to the legislator. Also, the court normally emphasizes these are not binding guidelines, or emphasizing that these guidelines are made just obiter dicta. This practice is really widespread, and it really comes close to what is called the practice of advisory opinions in US constitutional law. So again, by way of example, recently in May 2020, the court commented on the Czech criminal code on thresholds which serve for purposes of defining economic crimes. And although it emphasized the court is not normally empowered to supplant the role of the legislator in defining these thresholds, it severely criticized the fact that the thresholds in force have not been amended for a very long time, so they do not correspond with economic reality. And when discussing this indirect legislation by the Czech Constitutional Court, a specific attention must be paid to the practice of making declarations on omissions, on legislative omissions, or omissions made by the coordinate branches. This is the practice which had been discussed, had been originally criticized, but since 2003, the court has occasionally declared that the parliament has failed to adopt specific acts, and that such a failure constitutes a breach of the constitution. So to sum up, there is a plenty of situations in which the Constitutional Court in fact legislates, defines or codefines what constitutional law is and what ordinary law is or shall be. By way of conclusion, some attention should be paid to political reaction to judicial legislation which does exist in the Czech context. And surprisingly, when going through 3 decades of the history of the Czech Constitutional Court, we will find many examples of criticism, but generally this criticism is linked to individual cases. It's quite rare to see some more profound criticism of judicial legislation as such. The notable exception in this regard is definitely the Melchák judgment or judicial salary saga. But apart from these extraordinary situations, no open attacks on judicial legislation by the Constitutional Court of the Czech Republic has been organized or has been noticed in the Czech context. What is definitely interesting when analyzing political speech and political debate in the Czech Republic, the court is generally attributed a rather strong weight. So a colleague of mine, Jan Chmel, who analyzed the debates in the Chamber of Deputies in 2013 and to 2018, found that very often case law of the Constitutional Court serves as the argument either for the government to support their bills or to the opposition to challenge the bills tabled by the government. And even the executive, as can be demonstrated by the approach of the presidential office, has never openly attacked the practice of judicial legislation by the Constitutional Court. So for the time being, the court remains rather well positioned in the Czech political system. And the fact that it legislates is generally taken as granted. So for this moment, that's all from my part. So thank you very much for your attention, and I'm looking forward to further debate.
Thank you very much, Jan, for the interesting presentation, and sorry for interrupting you at the very end. Just I thought that these the last slide about the political position and the acknowledgement of the Constitutional Court in the political cohesion is extremely interesting indeed. But I thought that it really needs a lot of time to discuss that as well. And we have time constraints, unfortunately. So I give the floor first to Pozsár Zoltán Szentmiklósi, Pozsár Szentmiklósi Zoltán in Hungarian, who is actually my roommate at the ELTE Law School, associate professor at the ELTE Law School, and he will talk about the Hungarian case. The floor is yours.
Thank you very much, Fruzsina, and I would like to thank you to Monika for the invitation. It's really a pleasure, a distinct pleasure to be here among excellent colleagues, and it was really a joy to be part of that journey, writing the book on this extremely interesting topic. Thank you for that. I would like to talk to you briefly on the Hungarian experiences related to the lawmaking activity of the Constitutional Court. And I'd like to start with a statement which was made by Fruzsina, Eszter Bodnár, and myself several times when we write regularly reports on the activity, on the yearly activity of the Hungarian Constitutional Court. Usually sum up our findings with the statement that the court is not an effective control body of the political organs anymore. It was in the past, but nowadays it's in more control of the judiciary. And the main reason for that is the change of competences. Instead of actio popularis, we have constitutional complaints, and many other reasons can underline our statement. But now I'd like to focus to another question, the question whether the activity of the Constitutional Court, which can be described by positive lawmaking considerations, I will explain a couple minutes later this term, whether this activity can also strengthen this position or this negative position of the court, not limiting and not controlling the political organs. If we start with an overview of the position of the court, one can say that at the beginning of its activity, it had a significant impact on the building process of the state governed by the rule of law, and the court was a powerful counterbalance of the political powers. And since the enactment of the fundamental law and the new act on the Constitutional Court, as I have mentioned, significant changes were taken in the independence, the competencies, and the profile of the court. And the main focus of the court is by examining constitutional complaints on the activity of the judiciary. But if we focus on the lawmaking activity in general of the Constitutional Court, we can divide between different layers of this judicial lawmaking activity. The simplest one is the so-called, I call this explicit lawmaking activity, because the act on the Constitutional Court enables the court to create the rules of procedure of the Constitutional Court itself. This is a normative act, and these rules belong to the activity and the business of the court itself. This is a clear situation. The court is authorized to create those laws, those rules. And I call a different layer of lawmaking activity lawmaking by constitutional interpretation. And by this, I focus on informal constitutional amendments. Again, together with Fruzsina, another Hungarian colleague, Tímea Drinóci, we just found that in the past 30 years, it happened 12 times that the court interpreted the Constitution in a way that as the result of the interpretation, a new norm to the Constitution was created. For example, if there was a conflict between the president, the head of the state, and the prime minister, the court had to interpret the competencies and the role of the president within the parliamentary system of government of Hungary. And as a result of this abstract interpretation, the court, for example, created a new competence for the president, the power to refuse appointments, to appoint certain state officials if the president has well-founded questions whether the appointment could create a danger for the democratic functioning of the state. So by way of constitutional interpretation, the court produced sometimes informal amendments to the Constitution. That is what I'm calling lawmaking by constitutional interpretation. Today I will not focus on negative legislation because that's the classic modality of having effect or having an effect on the legislature, but I would like to focus on the positive lawmaking considerations. And by this, I mean two types of legal consequences which originally are designed to be exceptional legal consequences, because the main consequence could be the annulment of the challenged piece of legislation, invalidation of the challenged piece of legislation, and these are extraordinary legal measures which can be taken. The legislative omission was also mentioned by Jan Malir. In the Hungarian context, this means that according to the court's interpretation in a certain topic, the legislature has a duty to regulate a certain topic, and the parliament does not fulfill with this duty. Therefore, it has to create a law in a certain topic, or it has to amend a certain regulation. One example how it works, for example, in 2005, 1 year prior to the parliamentary elections, the Constitutional Court found that the regulation on the parliamentary elections related to the single member constituencies is not constitutional, because there are no standards and no safeguards how to re-examine the boundaries of those constituencies, because after a certain time, extreme differences could be in the number of the population of the different constituencies. Therefore, the right to vote is not equal anymore. But the court just didn't annul that piece of legislation 1 year prior to the election. Rather, it expressed that there is a legislative omission, therefore the parliament has to enact a new law in that topic. So this is a reasonable step taken by the court. In many other cases, there were formulated omissions. I will tell you the numbers a couple of minutes later. The second legal tool, legal consequence, which can be used by the court to influence the parliament or other organs without invalidating any piece of legislation, is formulating so-called constitutional requirements, which means that according to the court, there's no problem in general with the examined piece of legislation, but there's a compulsory way of interpretation of that piece of legislation. So this constitutional requirement is compulsory for all other stakeholders, for all organs, for the judges, for the state organs when dealing with that piece of legislation. And again, the court in that case is not forced to annul to invalidate the legislation, rather to formulate the way of interpretation of that legal act. An illustrative example for that is the so-called criminalization of homelessness case from 2019. So it's a fresh case in Hungary. This was a hot topic on the political agenda. The governing parties claim that they will react on the homelessness problem, they call it so. They even amended the fundamental law, letting the parliament to enact a legislation which could prohibit habitual dwelling on public spaces. And accordingly, the Act on Misdemeanors was amended and a new piece of legislation was included. So nowadays, it is prohibited to live on the streets. And after the third warning of the police, court procedure will start, and the court in the end can even finish the case with confinement. So it is crystal clear that this regulation affects human dignity. And the Constitutional Court examined this new piece of legislation, the new provisions of the Act on Misdemeanors. However, the court did not annul this piece of legislation. Rather, it explained how to interpret that piece of legislation, how to interpret the Act on Misdemeanors, not to enter into direct conflict with the human dignity provisions of the fundamental law. So again, what happened, the court was not brave enough to invalidate legislation, which was important for the politics, rather explained some constitutional requirements, how to interpret that piece of legislation, how to act in the future. Have some numbers which can show you the trends. Focusing on the past 5 years, if we look at the numbers in how many cases there were annulments of challenged pieces of legislation altogether in 36 times. And if you have a look at the exceptional legal consequences, the legislative omission and the constitutional requirement, we have 31 and 32. So almost identical numbers for general legal consequence in the case of problematic pieces of legislation, the invalidation, and for the exceptional legal consequences, legislative omission and constitutional requirement. So going back to the original question, I call omission and expressing constitutional requirements positive lawmaking considerations, because in those cases the court formulates in a positive way the required interpretation or the required substance of the norm That is the positive nature of this kind of activity of the court. And according to my understanding, this kind of positive lawmaking consideration trend strengthens the position of the court not to enter into direct conflicts with the political organs, rather to have a step back and keep itself silent in politically sensitive cases. That was my summary. Thank you very much for your kind attention.
Thank you very much. I muted myself because the heating is very, very loud. So thank you, Zoli. Your summary was very thought-provoking. I was answering some of the questions addressed to me in the chat concerning the Hungarian case. So I hope you do not mind. But I gave already some answers. And now the floor is of Max Stoyer and Jan Stavinsky. We are traveling to Slovakia. So the floor is yours. I don't know which one of you will start.
Yes, I will start, Florczina. Thank you very much for the kind introduction, and thank you very much to all of you for being here, as well as to Monika for her leadership and all of the coordination efforts for this project. I hope you can see my slides. As already mentioned, I had the honor to co-author this chapter with Dr. Jan Stiavnický, who is a legal advisor directly at the Constitutional Court in Slovakia, and unfortunately he could not join us today. He apologizes due to high workload at the court at these times. And the way how we structured the chapter is through a dialogue between what we call a view from the inside and the view from the outside. The view from the inside being that of Dr. Stiavnický, who is directly at the court, and the view from the outside being my analysis that, of course, still is being informed by the Slovak jurisdiction, being based in the Slovak jurisdiction, but not directly at the court. And I will try to do justice to his inside view as well, and I invite you to read that segment later on. As you can see here, there is a question mark added to the title of this presentation, which you will not find in the title of the chapter. And certainly in the outline that we would like to present. So there is an emphasis on the Slovak case, of course, but I would like to start with a few general reflections on lawmaking by constitutional courts and how we can then understand that in the Slovak context before moving on to Dr. Stiavnický's analysis of the types of lawmaking activity in the Slovak case, and then my analysis of the reflections of this lawmaking activity by a range of constituencies in the Slovak public discourse. Hans Kelsen was mentioned several times in this webinar already, and of course he is the originator of the concept of negative legislature. But I would like to highlight the attention and submit for discussion that the idea of lawmaking is also quite close to HLA Hart's account of the courts legislating in the penumbra of the rules. So when the law runs out, there is a gap in the law and the courts need to fill in that gap, and therefore they act as deputy legislatures. Now, this view is opposed by Ronald Dworkin, who highlights that the law is already there. And of course, courts engage in interpretive activity, but they only discover the law. They do not legislate. And in terms of, we don't need to adopt a staunch position here, but what we try to highlight is that language matters, that if we present the activity of the constitutional courts as lawmaking activity, then of course there is this natural perception that the courts interfere with the legislature, because legislation is the domain of the parliament, adjudication is the domain of the court. And while we are using the concept of judicial lawmaking, we do highlight that by merely doing its job, the court may give the impression of interfering with the legislature, but just because whenever it even just invalidates a certain provision, there is something coming in place of that provision, and I will get back to that point later on, there is a certain activity that we could call lawmaking. And so the court does not, of course, necessarily interfere with the legislative powers just by engaging in judicial lawmaking. So after this brief clarification and introduction also for the conceptual discussion, let's move on to the Slovak case. The Slovak Constitutional Court has very extensive review powers. It contains almost 19 different types of proceedings, which means that it is probably at the moment the most powerful constitutional court from among those in this webinar. Of course, until before in Hungary, while there was the Actio Popularis, that was not the case. But that means, of course, that it has a very wide leeway for engaging in judicial lawmaking of different kinds. And another feature that might be worth mentioning is that the Slovak court, particularly in the regional context, is known as having undergone a battle with a semi-authoritarian regime of Vladimir Mečiar in 1994 and 98. So when we try to create an account of its lawmaking activity, we do need to pay attention to this political context of its battle with the semi-authoritarian regime, that it's conventionally believed it has succeeded in this battle, that the court has contributed to protecting democracy at this time. So what are the types of lawmaking activity? And this is the classification that Dr. Štiavnický offers in his part of the chapter, and that we engaged in dialogue with. So precisely starting with that point on the Mečiarist regime and the struggle against the Mečiarist regime in the 1990s, some of these decisions in the 1990s in particular were merely supporting, in a way, majoritarian notions of democracy, right? Merely supporting majority rule, for instance, by preventing the stripping of a mandate of an MP who was not supportive of Mečiar's regime at a certain point, vis-a-vis narrow partisan interests. So the court did not present any kind of robust notion of democracy or any kind of robust understanding of values or constitutional principles, but it still managed to act as democracy giver, and in those decisions, and therefore still engage in this particular form of lawmaking activity that then may be featured also in some of the other forms that we present. Now, very close to some of the other cases that we've heard today is the positive constitutional giver or the positive supraconstitutional legislature that is overriding a parliamentary supermajority decision and deciding on the unconstitutionality of constitutional amendment. Slovak court joined the stream of courts that declared their allegiance to this doctrine in 2019 when it overrode a constitutional amendment in the so-called judicial security clearance cases. And it's worth noting that in this case, very much what was at stake was the scope of judicial power. It was whether the executive has a role in determining security clearances for judges. And this focus on judicial power and more broadly the concept of judicial independence can be very much seen in other cases of the court as well, which don't concern constitutional amendment. And so the next category is that of positive, not only law, but also policymaker, and particularly policymaker in terms of judicial policy design of the design of the judiciary and of judicial independence. Here, there is also the special court case, the invalidation of the special court by the Slovak Constitutional Court. And these are some of the strongest decisions that we can also identify in the Constitutional Court case law. Now, strongest decision is a phrase that is used by the Judicon project, the project on judicial constraints on legislature in Central Europe. And I think it is fitting to mention it here because it correlates with the policymaker role of the Constitutional Court. Another forms of judicial lawmaking that can be identified are, of course, the broader constitutional interpretation. So I mentioned that the Slovak Constitutional Court has a very wide scope of review powers. And among these is also the power of constitutional interpretation that I think we just heard is also the case in Bulgaria. According to Article 128 of the Slovak Constitution, the Slovak court can give abstract constitutional interpretation if there is a dispute over the meaning of the Constitution. It has done this in several cases. For instance, in investiture controversies, so to speak, in controversies over appointments of various officials or intra-executive conflicts between the president and the prime minister. So we can definitely see this trait in the case law of the Slovak court as well. Now, going back to that point of the lawmaking basically necessarily entailing or the activity of the Constitutional Court necessarily entailing the renewal of a certain form of regulation, this is the point highlighting that the court acts as a resuscitator by bringing earlier regulation to life, right? So the court must pay attention to the fact that even if it just invalidates a particular provision, there will be something else coming in place, or even if there is no regulation, that will have certain implications. So in these cases, in basically all wide variety of cases, the court acts as a resuscitator. And from the internal perspective, as Dr. Stianic highlights, it's important to pay attention to this. The court finally also fills in various lacunae, various gaps. Now, this, of course, is close to the Hartian concept of judicial lawmaking, but it may do so not necessarily by declaring a provision unconstitutional, but by exerting obiter dictum forms of pressure in the parliament. So the justification of the court's decisions are also very important, and they can entail this kind of dialogue with the parliament. We can discuss some examples later on. So to summarize, these categories account for the unique scope of formal powers of the Slovak Constitutional Court, and they pay attention, besides, of course, adherence to the general categories that are identified in the book, to also the temporal dimension, to the renewal of regulations that were in place in case of invalidation of a certain previous regulation. Now, let me move on to the reflections of the lawmaking activity by a range of constituencies in Slovakia. So I identified three key epistemic communities channeling public perceptions. It is, by the way, very difficult to discover what the public really thinks about the Constitutional Court in Slovakia, because there are no public opinion polls or surveys. But these three constituencies, media, experts, and political elites, certainly do have some channeling role towards the public, and of course their views themselves are relevant to consider. So the mainstream media, we can observe differences across the terms of the court, the terms of the court being according to the presidents of the court, and we had a long period from 2007 to 2019 under one president, so that is called the third term of the court, and currently we have the fourth term of the court. And particularly in the third term, we can see more general, more critical attitude of the media towards the court's decision making, but not generally towards the court's lawmaking activity, towards those particular examples or types of activity that I listed before. However, what we can see, and I think this is similar to what Jan Mališ told about the Czech Republic, is that there is reflection on particular cases, and there might be opposition on particular cases. What is different, and that is particularly the case with experts, with some experts at least, is that the tendency is there to derive from criticism of individual cases criticism of the court's decision-making powers as such. And perhaps this is a difference from the Czech Republic then. And of course, among experts are also former judges who, particularly now that we had this third term ended, contribute more intensively to the public discussion. And in a way, the separate opinions that Slovak court can issue also contribute to this debate. There is a tendency, however, among experts to focus on the relationship between state institutions, for instance, on these appointment controversies on judicial power, and less emphasis is placed on individual rights, perhaps because, of course, the lawmaking activity is not so obvious in dealing with individual rights complaints. However, then the picture about the court is a little bit skewed in the public discourse. Finally, political elites. Now, unfortunately, we do have cases where political elites overrode Constitutional Court decisions with a constitutional amendment. We have one case from 2006. I will not go into it now, but we have also one case very recent, just from last month, from December 2020. And perhaps I can conclude with that point on the Constitutional Amendment Act from December 2020 that introduced quite significant changes to the court's operation. And the most important one for our purposes is this kind of pushback against the lawmaking, against this particular form of lawmaking of supraconstitutional interpretation by removing the competence of adjudicating the constitutionality of constitutional amendments, at least the constitutionality of constitutional amendments with the Constitution, not with international treaties. That is another conundrum that we would need to discuss. However, it does signal a pushback against the court, and now actually the court needs to decide whether this constitutional amendment about the restriction of the constitutional amendment powers of the court is constitutional, because the opposition has submitted a complaint precisely on this constitutional amendment to the Constitution. And this is a decision that the court is facing currently, and that it needs to decide about. So it would be very interesting to discuss what are the possible avenues also for the court here, whether it should resist the effort to curtail its competencies through invalidating that other constitutional amendment, or whether it should build up resilience via other means, and what does that mean for the lawmaking activity. There are a few other questions that I highlighted, but I'm sure there will be some coming from you as well. So let me stop here, and thank you very much for your attention.
Thank you very much, Max. And also we thank a lot to Jan. Please tell him, because the chapter and the presentation is extremely interesting and an added value to this research that Monika initiated. And the last speaker is the organizer of the project. So Monika, the floor is yours, and I hope that we will hear not only about Poland and the Polish case, but also maybe a little bit about your overall assessment of the results of this challenging project.
Yes, it's true. Thank you very much, Frosina. I will start with the uploading of my presentation. I hope that you see this. Yes, generally I wanted to say firstly about the methodology, or maybe just some remarks about the methodology of our research. Secondly, about some main conclusions, although some conclusions concerning those 4 countries have already been presented. And finally, I would like to mention some new trends identified as those requiring further more detailed research in this area of judicial lawmaking of constitutional courts. So when it comes to the methodology, yes. So when it comes to the methodology, we decided to include into our research 6 countries from this region of Europe. In this group, there were all Visegrad countries, as you can see: Poland, Hungary, the Czech Republic, and the Slovak Republic, as well as states representing the Baltic countries. It is a case of Latvia, and the Balkan countries, and it was Bulgaria. Generally, these are post-communist countries in which new democratic constitutions were adopted in the 1990s, and constitutional courts were established as the guardians of the new constitutional order. However, these general remarks do not apply to the 2 countries we selected for the study. Firstly, in Latvia, the constitution passed in 1922 was upheld, and a new constitution was not adopted in the 1919, unlike in other countries from our region. So the Latvian Constitutional Court that was established in 1996 became the guarantor of the new democratic legal order based on this old, of course, amended constitution. And secondly, the Polish Constitutional Court, it was established in 1985 under the Communist Constitution that was enforced at the time. Obviously, it was not created with the idea of being the guardian of democracy and the rule of law. It was designed as a weak organ controlling the constitutionality of statutes under the parliamentary supervision. Its ruling declaring unconstitutionality of statutes were not final and could have been even rejected by the parliament. So the role of the Polish Constitutional Court changed only in December 1989, when the principle of a democratic rule of law state was introduced into this communist constitution. And from that moment, the Constitutional Court took the position of the guardian of this principle. However, only in 1997, when the new Polish constitution entered into force, the Polish Constitutional Court became an independent body entitled to adjudicate on the constitutional of law, including constitutionality of statutes. Before starting our research, we formulated 3 questions that we wanted to answer on the basis of the comparative analysis of the case law of the constitutional courts in these 6 countries, also, of course, in the countries of the Western Europe that were included into the book. So these questions that were formulated were as follows. I mean, those are the main questions because, as you remember, we had more such kind of questions in the formula. So do constitutional courts create the law or they just apply it? The second one is the interpretation of the Constitution, this particular interpretation that is made by the Constitutional Court of a creative or purely reconstructive nature. And thirdly, can the Constitutional Court develop, correct, and supplement the law, or should it limit itself only to the comparison of a provision in question and assessment of its compliance with the Constitution? One of the main problems we had to tackle with in our research was how to define the concept of judicial lawmaking for the purpose of our studies, of course, because this concept has been already defined in the literature, and whether it is the most appropriate concept to describe the impact of the constitutional courts on the legal order of our state or generally on legal orders of a state. As an alternative to other concepts could be considered or could have been considered at the time, namely the concept of the development of the law by the Constitutional Court, so the German concept mainly, and on the other hand, the concept of the Constitutional Court legislation mentioned by Jan today. So we included also those other concepts, but I think that we decided to make this concept of judicial lawmaking as the main concept, as the main notion in our book. And that's why we decided to define very broadly this notion of judicial lawmaking, so that it takes into account various ways in which the constitutional courts influence the legal order. So judicial lawmaking in our understanding includes the repeal, modification, and supplementation of the law by the constitutional courts within the scope of constitutional review, but also as a consequence of constitutional review. Such a concept of lawmaking is applied through the interpretation of law, including, of course, in the interpretation of the Constitution, the interpretation of law in accordance with the Constitution, and in a manner that is friendly to EU law and international law. And this broad concept of lawmaking is applied also through adjudication on constitutionality of law, combined with the determination of the extent of the declared unconstitutionality and the legal consequences of the constitutional court rulings. Moreover, we indicated that constitutional courts have also normative competences sensu stricto, as they are entitled to issue internal rules concerning the organization of the constitutional court itself, or the procedural issues before the constitutional court. In our research, we assume that judicial lawmaking is provided differently at the constitutional level and at the sub-constitutional level, mainly the statutory level. The constitution is developed at this constitutional level. When we talk about this constitutional level, the constitution is developed by the constitutional court mainly through the interpretation, which is essentially, as we know, creative, mainly because constitutional provisions are formulated in a highly general way and leave just room for various understanding. In countries of our region, I think the two main sources of inspiration for the constitutional courts in this process of developing the constitution through interpretation can be identified. The first source, paradoxically, is the constitution itself, especially its general principles and the axiology of the constitution. So the constitutional courts derive from the general principles expressed in the constitution more specific principles, which are treated as constitutional principles, although they are not directly expressed in the text of the constitution. Such a constitutional-friendly interpretation of the constitution makes it possible to build the authority of the constitution and to, of course, to protect the constitutional values and so on. And the second source of inspiration for the constitutional courts of our region are the European standards derived from the European law and European Convention of Human Rights. Those standards are implemented by constitutional courts into the national constitutional orders through a European Union friendly or pro-conventional friendly interpretation, or pro-conventional interpretation of the constitution, pro-EU or pro-conventional interpretation of the constitution. So this type of interpretation quite often, although not always, of course, is a sufficient instrument for resolving potential conflicts between constitutional standards and European standards. Judicial lawmaking at the constitutional level does consist primarily of, as I said, creative interpretation of constitutional provisions that are formulated in a very general way. Obviously, the task of the constitutional court is not to concretize the constitution, just to concretize the constitutional provisions, but also to develop them and to adopt them to changing social conditions, for instance. The most creative interpretation of the constitution that we identified in our research, which is also a very obvious conclusion, is that interpretation concerning the constitutional principles and provisions on rights and freedoms of an individual. So various examples of constitutional principles can be given, the actual content of which were determined not by the way in which they are expressed in the constitution, but by the way in which they were understood and applied by the constitutional courts. The best example, of course, is the principle of a democratic law-governed state, which was described in most chapters of our book as this principle that was developed and that was the source of other more specific principles derived by the constitutional courts. And the second domain of constitutional regulation that is particularly susceptible to creative interpretation by the constitutional courts is that of the provisions on the rights and freedoms of an individual. So interpretations in this area sometimes has been creative sensu stricto, since constitutional courts supplement the constitution with the new individual rights and freedoms that have not been explicitly stated in the provision. And one of the best examples for this practice, I think, is the Polish case. Before 1997, the Polish constitutional court inferred from the principle of a democratic law-governed state such rights as the right to privacy, the right to legal protection of life, the right to a fair trial, for instance, although the communist constitution in force at the time did not guarantee this rights expressing verbis. Important element of judicial lawmaking at the constitutional level is also the setting of boundaries for the constitutionally acceptable interpretation of the constitution and for constitutionally compatible amendments to the constitution. So for this purpose, constitutional courts of our region have developed the concepts of constitutional identity or the concept of constitutional core. Although only the Czech constitution contains unamendable provisions, I mean those that were presented among those presented today, the constitutional courts from other countries covered by our studies also consider themselves as having the competence to protect the inviolability of the constitutional principles that determine the identity of the constitution and that constitute the constitutional core. And of course, in cases where explicit constitutional decisions on the eternity clauses are lacking, the Constitutional Court adjudicates which constitutional provisions cannot be amended. And such examples of rulings can be identified in the case law of Slovak, Polish, and also Czech constitutional courts. Some of the constitutional courts not only consider themselves as competent at examining constitutionality of the amendment of the constitution, but they even found amendments to the constitution to be unconstitutional. This applies to the Bulgarian, Czech, and the Slovak constitutional courts, and it was also described in our book. At the statutory level, changes in the law made by the Constitutional Court are not so much a consequence of lawmaking interpretation, I mean at least lawmaking interpretation of the Constitutional Court, but they are a consequence of Constitutional Court rulings. So the Constitutional Court rulings on the lack of constitutionality of the state result in negative effects, namely an unconstitutional statute, its provision is repealed and ceased to be part of the legal order. And such a situation may create a legal gap that may be more unconstitutional than the regulation that was removed from the legal system by the Constitutional Court, and therefore the constitutional courts, also the constitutional courts of our region, have developed different instruments for preventing the emergence of a dysfunctional legal gap as a result of the rulings. So the first is when the matter regulated by the legal norm that was removed by the Constitutional Court due to its unconstitutionality can be covered by the scope of the regulation of another legal norm. This situation happens quite frequently, as the removal of one norm from the legal system usually results in filling its scope of regulation with another norm that still remains in this system. In this way, a negative Constitutional Court ruling simultaneously gives rise to positive effects, modifying the scope of the regulation of the provisions that were not even examined by the Constitutional Court. A statutory norm that has been removed from the legal system can be replaced by another statutory norm or by a constitutional norm that is concrete and suitable for direct application. And of course, there are a lot of cases, situations when such kind of covering one norm by the other one is not possible. And that's why the constitutional courts use also other methods of postponing the derogation effect of the rulings. So the first one is that they can defer entry into force of the Constitutional Court ruling. And as we know, if the Constitutional Court defers the entry into force of the ruling until the moment stipulated in the operative part of the ruling, the provision found to be unconstitutional temporarily remains in force, and as a consequence, it should be generally applied by all public authorities during that time. In some countries, such as Poland, the maximum deferral period is set by the constitution. In others, like in Latvia, for instance, the Constitutional Court has broad discretion to specify the length of the deferral period. And the other way, I'm not going to elaborate maybe this issue, but just to mention the other way of avoiding a legal gap that is the institution of the restoration by the Constitutional Court, the previous, the amendment wording of the provision, when it finds that the provision amending the other provision is unconstitutional, and it was used by constitutional courts of our region, including Polish, Latvian, Bulgarian, and Slovak constitutional court. We establish also that the constitutional courts of our region increasingly rarely state that the provision being examined are entirely unconstitutional, and increasingly frequently hold that they are partially unconstitutional. And this ruling that a provision is partially unconstitutional can have more far-reaching effects than a ruling that the same provision is unconstitutional in its entirety. This is because a provision that is declared partially unconstitutional continues to operate in the legal system with the new normative content that was determined by the Constitutional Court. However, the main problem with partial rulings is that they modify the normative content of a provision while keeping its wording unchanged. This in turn gives rise to difficulties related to establishing the actual scope of the normative change arising from this type of ruling. And this situation is in most cases required the reaction of the legislator, required the reaction of the parliament in order to adjust the wording of the provision to its new normative content determined by the Constitutional Court. And we also found other quite similar institutions that were applied by constitutional courts simultaneously in our country, but I don't want to take maybe more time and just mention here like the conditional constitutionality, also the negative positive interpretative rulings. Maybe we can discuss about this later, and also the omission, of course. Finally, I'd like to briefly mention two trends that can be observed in Hungary and since 2010, and also in Poland since 2015, and which leave the room for further discussion on the problem of judicial lawmaking of constitutional courts. So firstly, the constitutional courts in these two countries have become politicized in recent years, whereby the ruling parliamentary majority has filled them with, as we know, their own judges. The main task of this new constitutional courts has become the firstly the legalization of constitutionally adaptable pieces of legislation that have been adopted by the parliamentary majority. And instead of controlling the activities of the parliament, the constitutional courts in Poland and Hungary have started to execute its political decisions, sometimes the political decision of the parliament, of the majority, sometimes too inconvenient to be made by the politicians. A ruling on abortion issued in October 2020, we're talking about this before the webinar, is a good example illustrating this problem. So this type of constitutional court activism poses a serious threat to the democratic constitutional order and also its underlying axiology. And I think that it is the issue that we should that should be the topic for the further research. And the second trend that can be observed in Poland and Hungary for this moment concerns the changing role of the Constitutional Court in the protection of individual rights and freedoms. In democratic states, judicial lawmaking has been justified very often maybe even always, or by the need for the protection of human rights and freedoms, or by the necessity to continuously develop constitutional standards toward increasing the protection of human rights and freedoms. However, in countries where traditional constitutional courts have found themselves in crisis, so in Poland and Hungary, the role of the guardian of constitutional standards has been taken over by international courts, namely the Court of Justice of the European Union and the European Court of Human Rights. This is perfectly illustrated by the situation in Poland, when the number of legal questions and constitutional complaints submitted to the Constitutional Court has declined dramatically during the last four years, while the number of complaints on constitutional matters submitted by citizens by judges also to the European Court of Human Rights and the corresponding preliminary questions referred by the Polish courts to the Court of Justice of the European Union have increased. Since the, as we know, since the allegation of a breach of constitutional standards cannot be formally raised before the international bodies and also international courts, those two international courts, it is transformed into an allegation of a violation of the European Convention or violation of the European Union law and European Union standards. However, the same standards are still at stake as regards, for instance, non-discrimination or the protection of human rights and freedoms or independence of judiciary and the separation of powers. Therefore, there is no doubt that in those states where the Constitutional Court is being marginalized or even actually disappearing, the Constitutional Court's role is being taken over, at least to some extent, by international courts, which are the guardians of the European standards developed on the basis of the constitutional standards common to the member states associated with the given organization. So just in conclusion, I just wanted to emphasize that in our book, we have just identified those two trends. But since our aim was to describe the judicial lawmaking activity of constitutional courts since they were created, and not only in the context of recent changes in Poland and Hungary, therefore we indicated these two issues as those requiring further and more detailed research. Thank you very much.
Thank you very much, Monika. Indeed, we got a great picture about the research itself and the main findings of the research. I would like to ask you how much time we have for the Q&A session, because I'm not sure if we have half an hour now. We are a bit late with the.
We have half an hour. Yes, half an hour.
Okay,
yeah.
I thought that that maybe we have time until 4:30. So I would like to ask you to introduce questions. You can only use you can also use the chat function. Maybe for the participants, it would be better to raise the hands, or maybe just you can pose questions directly. But for the audience, the chat function, we do not have Q&A function, so the chat function should serve as a forum to pose questions. So I'm asking if anyone would like to start.
We have a question from Professor Halmai, I think.
Please.
Thank you. Thank you very much for this really very interesting presentations and overview of the 6 countries' practice. Let me have 2 comments or questions. So the first is a little bit of a challenge to Monika's first challenge. namely about Poland and Hungary. So you formulated the challenge in a way saying whether judicial lawmaking in Hungary and Poland threatens democratic constitutional principles. I do not remember fully the challenge, but this was the essence of your formulation. So let me ask whether the issue is rather the opposite, namely that it's not so much the judicial lawmaking which threatens democratic constitutionalism in those two countries, because and in that respect, I fully agree with Zoltán Pozsár-Szentmiklós's very first introductory sentences, saying that in Hungary there is no such thing as judicial lawmaking in the sense of real judicial review of lawmaking. So, in other words, those constitutional courts, I would say sham constitutional courts or fake constitutional courts, in other words, not independent courts anymore, do not really exercise any kind of judicial lawmaking, because they very much comply with all the lawmakings of the governments and the parliaments in the country. So the problem is the opposite. There is no such thing as judicial lawmaking in those two countries. The only example Zoltán gave was from 2005. So from the old courts. The current case, the 2019 case on the homelessness case, it wasn't a judicial lawmaking. The Constitutional Court very much agreed with the lawmaker in the essence of the law. In other words, my concluding remarks on that would be whether it really makes sense to include those two countries nowadays as actively contributing in judicial lawmaking. My very short other comment regards to the other real constitutional courts in the region. I think it would be a very interesting probably follow-up question for a research to look at the state of precedents in constitutional adjudication and in lawmaking. The example of Martin Belov in the very first presentation was very interesting, how the Constitutional Court in two decisions in 2003 and 2004 contradicted to each other. So the question is, what is the role of precedents? Whether the courts are obliged to follow previous case law or not, because this is also a way of amending or not amending in judicial lawmaking. Thank you very much.
Thank you very much for the questions, Gábor. Addressed already to Zoltán, Monika, and Martin about precedents. So if you do not mind, at least at the beginning, I would give the floor back to the addressees of the questions. So please, Zoltán first, and Monika and Martin, please.
Thank you. I very much agree with Professor Halmai that we have here, like let me say, a paradox. In my interpretation, we just lost the standard, because one can agree that, of course, the Constitutional Court itself can claim that it has democratic legitimacy. So not only the Parliament has the democratic legitimacy behind it, the court, it has also, of course, there's a chain of legitimacy. So the question is not, or maybe is not only whether the court threatens with its decisions and judicial lawmaking activity, the decisions activity of the parliament. We can, of course, ask vice versa, whether the court itself can be a representative of the democratic values as an addressee to the parliament. But if we just lost the democratic standard, no one knows who is right in that debate. So I really do not have an answer to that challenge, but I'm very much waiting for other interpretations and questions. Thank you.
Thank you. Lech Garlicki would like to have a comment on this specific question, if I understand well. So please, Professor Garlicki.
Thank you. Just a very brief comment. I must say I'm closer to Monika's approach than Gabor is. Of course, the situation and the content of the case law of both courts, Polish one and the Hungarian one, are nowadays completely different than it should have been in regular times. But still, there is some degree of lawmaking in this. I would call it a confirmatory lawmaking. If a constitutional court, and of course I'm not an expert in the Hungarian case law, but this is visible in the Polish case law. The constitutional court takes decisions. These decisions sometimes claim to invalidate the existing laws, which is welcomed or inspired by the government. This is another sense, but still there is a change in the content of law, and this is usually justified by some reasons. We may accept it, we may not accept it, but again, this is an imitation of the same technique, only in an, let's say, less licit goal. And then we also have situations in which the Constitutional Court simply decides, yes, this particular regulation is constitutional. But what does it mean? It means it establishes a certain interpretation of both constitution and the law. So we can claim that this is abusive. We may not like it. We may say this is something uncomparable to normal times and the normal activities of the courts. But I think that on both sides on the equation, I mean, authoritarian and democratic activity of constitutional courts, this confirmatory jurisprudence also may have a very important contribution to deciding what are constitutional principles, what is the understanding of the laws, etc. So I would say, unfortunately, but this activity of the Polish Constitutional Court may have impact on lawmaking, and this impact may be detrimental, particularly in the future times where the court may remain the last bastion of protection of the present system against some political changes elsewhere. Thank you.
Thank you very much. Joining to this, I also wondered if judicial lawmaking can be understood also as a lawmaking that is complementary to the legislative actions and governmental actions. So I also wondered if lawmaking can be conceptualized also in a sense that is not only contradictory or in the review process not only against the political schedule, but complementary to that, what we observe in Hungary. But I give the floor back to Monika to clear the concept of the book on this matter, or defend her approach.
Well, I'd like to say that I partially agree with Professor Gabor, but only partially, because partially I agree also with Professor Garlicki. I think that Professor Gabor is right, talking that it's no sense to to analyze at the same time the Hungarian and Polish constitutional courts, which generate so many problems, legal problems nowadays, and the other constitutional courts where one can just analyze from the theoretical point of view. So that's why I think that it's great that we didn't decide to include those problems into our books, because I think it would be not possible to analyze at the same level and in the same field, I mean, the problems of our constitutional courts and those theoretical problems concerning with them lawmaking. But on the other hand, I do believe, as Professor Garlicki said, that there is a law-making activity in the, at least when it comes to the Polish Constitutional Court. We can just we can see now that in this cooperation with the government, the role of the Constitutional Court is very important. So I see, for instance, this positive impact on the law. I mean, positive not because it is positive, but because it's something additional. Firstly, in many judgments that we had, in which the Polish Constitutional Tribunal was trying to legalize the unconstitutional practice. So the practice that was obviously unconstitutional, and this those judgments that legalized this those practice, they made the practice in accordance with the constitution, so constitutional. So I think that it adds something new. And secondly, making unpopular decisions. We can observe this nowadays in Poland, and I think that the abortion is the great example of this, that we used to have a lot of initiative in the parliament, but this decision to abolish the legal abortion was very controversial. So that's why probably this decision was made by the Constitutional Court, in which we don't have to analyze, and I mean, we don't have to looking for any discussion or something like that. There is just a decision, and this decision had the same consequences as the legal regulations which changed the law on abortion. And also adjudicating on inconvenient regulations, not that are constitutional, but for the government or for the politicians of the government party are from some reason unconstitutional, are also made by the Constitutional Court. So that's why I think that this kind of activity, in this kind of activity of the Polish Constitutional Court, I'm not the expert when it comes to the Hungarian Constitutional Court, but we can observe this, and I think it's a great danger for the democratic order. So that's why I think that I said that judicial lawmaking, not as such, but such kind of judicial lawmaking that we can observe, such kind of activism of the Constitutional Court that we can observe nowadays in the case of the Polish Constitutional Court is this danger.
Mm-hmm. Thank you, Monika. And before I give the floor to Martin, can Andrei join the conversation and present his questions? Can you maybe let him in or give?
You mean Andre?
Hanulak.
Yeah, but I can't see him. I mean,
it's possible that you must let him into the conversation.
He's joining.
Yeah, maybe you can see me now. I'm not sure, or at least you can hear me.
Yes, great. Thank you, Monika.
Good afternoon to everyone. Thank you for beautiful presentations, all of you, and to Monika for organizing such an event. Greetings from the Republic, almost. I have one question, which is maybe a bit skeptic or rather provocative to all participants when you are speaking about the legislative activities, power, and the capacity of the constitutional courts to encroach to lawmaking questions. I'm always thinking about whether there are some real positivistic legal limits to options and of the constitutional courts to attract the legislative power, or whether we are getting somewhere extra outside of the legal discussion and speaking about the behavioral personal positions of the judges and the courts themselves, whether really we could think about some legal instruments preventing of the abuse of the option of interaction of the interference of the constitutional courts into lawmaking processes. This is something I'm always thinking about, whether this is only a balance or whether there are some legal rules we could follow. So this is my question, and thank you very much, Frushina, for getting me in. And I'm looking forward to your answers if there is some time.
Thank you very much. And also, in addition, I say that I was wondering if an activist legal what is the difference between an activist legal interpretation that we often use and you often refer to, and this kind of judicial lawmaking that you conceptualize in this project. So how we distinguish between legal interpretation, the different methods, and the volume of using one or the other extensive, how extensively we use in interpretation, and when it gets to judicial lawmaking, that should be assessed in the relation of separation of powers as well, and the judicial function. So with these very difficult questions, first I give the floor back to Martin Belov, because he was addressed firstly the question of precedents by Professor Halmai. So please answer all the questions raised if possible.
Thank you very much, Fruji, and I would like to thank Professor Halmai for that very appropriate question, because actually Bulgaria is traditionally a civil law country, so the precedent is something like a heresy, both from the viewpoint of valid law and from the viewpoint of theory. The Bulgarian constitutional anthropology, I would say, including both theoretical thinkers, judges, legislators, all players on the ground, is very much influenced by legal positivism in its different manifestations, and legal realism is rather limited, not to say about social legal studies. In the latter, I'm kind of the exception. So in that context, you can imagine that the Constitutional Court, as the Bulgarian one, which usually uses teleological interpretation, which usually uses activist practices, and in fact sets new rules, both with regard to the ordinary legislation and with view to developing the constitution, is rather an exceptional event, and it's not met with criticism. So that's a very interesting intellectual paradox. And the court realizes that it has to have a consistent practice, because actually First of all, this is what the people are taught in the university. Second, some of the judges are not only professors, but also lawyers coming from the Supreme Court. So they are aware of the fact that they have to stick to some consistency of their lawmaking, but still you can observe important deviations. For example, the case of these 3 decisions, not only 2, but 3 that I have just mentioned, when actually the court radically deviates from previous practice without considering both the previous case and the new case as precedents. I don't think that the Bulgarian Constitutional Court judges think that they are adopting precedents. Actually, they are not, from a strict sense, adopting precedents, because the court is not involved in the judiciary. So they are solving cases in abstracto. So in formal sense, these are not precedents, but I'm not sure if the potential of these cases is really realized. I would say that 10 years ago, we made a very interesting research with some colleagues. How do the judges and state prosecutors conceive case law, not only of the Bulgarian Constitutional Court, but also of the European Court of Justice and the European Court of Human Rights. And it was conceived a little bit like meta law. So there was real law, like written in norms, and something like meta law, some beautiful but supreme principles adopting cases. I think there was a huge evolution in the last 10 years. So case law is much more widely considered to be part of the Bulgarian valid law and legal order, and there is a trend towards reconceptualization of the status of these cases of the Constitutional Court. And I just want to briefly say something about what Andrei Hamulak asked. In fact, I think it's like trying to protect sandcastle from the waves of the sea. So the attempt to create strict legal positivist framework for the judicial activity of the courts, especially judicial activism, is something like that. Indeed, there are many limitations to this, not only in the Bulgarian case law, but also, of course, in the Bulgarian case, but also in many other systems, like that the court is bound to the subject to which it's approached. That's especially visible in the case of concrete control for constitutionality. The need to give reasons to give motives to the decision. The need to the requirement to stick to previous case law and to amend it only if there is a new substantial reason for that, and so on and so forth. But I think that the court can always avoid such limitations and overcome them without the constitutional legislator or the ordinary legislator being able to really limit the court. And finally, just a short remark to Fruji. I think that judicial self-restraint and judicial activism should not be viewed in black and white terms. There are quite many shades of gray in between, but I think that the crucial boundary which is passed when we can start speaking of activism is when the court starts to further develop the constitution and do that in a political way. So the criteria can be that self-restraint is limited to clarifying mainly judicial issues, although they have also political consequences. Thank you, Andrei. While judicial activism is a phenomenon which goes beyond and deeper into the woods of politics. This is also visible with view to the tools the courts use, because the courts that try to restrain themselves use much more historical interpretation or systematic or lexical interpretive methods, whereas the courts that want to expand make recourse to teleological or purposive interpretation. Thank you very much.
Thank you very much, Martin. And as we do not have much time left, if you do not mind, I would introduce the question of Michal Andrej Kajewski. And if you do not have any other questions at this moment, but I ask the participants to pose the last round of questions right now, if possible.
We have still two questions.
Okay, I see one. I do not see the other. Who is that?
Professor Leszczyński and Professor Zirk-Sadowski.
Right. Sorry, I just saw the one of these. Okay, then please post these two questions in this order that Monika suggested, and then I would like to give the floor back to the also to Max and Jan, if possible. And then we can close the session. So please, Professor Skajewski.
I understand that I'm the first on the line, yes?
Yes.
Okay. Thank you very much for the very interesting session. I think that it covers many items, not only important from the point of the constitutional law theory, but also from the theory of law. And that's why I would like to ask a question probably directed to the Professor Monika Florczak-Wątor, who distinguished the creative creative and reconstructive interpretation of the Constitution by the constitutional courts. I think that it may cover all constitutional courts which were presented in this, during the session. My question is, if we attach to this alternative the problem of the judicial lawmaking, should we modify the order of methodology of interpretation? I mean, the special proportions or relations between the linguistic and the systemic and functional methods of interpretation of the Constitution. This, it seems to me that it is important because of the special features of the Constitutional Court text, the subject of the Constitution, as well as the systemic connections with the other branches of law, which the paths of them are regulated by the Constitution. So, does it have any impact on the relations between the rules, or the interpretational rules of the Constitution, this distinction and the connection of this distinction with the judicial lawmaking problem? I mean, I would have some more questions, but I understand the lack of time is just rather more important than my problems. Thank you.
Actually, this is unfortunately not true. I'm always a bad moderator because I hate closing the sessions and interrupting people, because I do not agree with this, that time would be more important than the problems and the questions. But still, I have the task of moderator. So I would give the floor to Professor Garlicki.
Professor Zirk-Sadowski.
Yeah, sorry.
Mm-hmm.
Thank you very much. Well, it's the problem with Polish names, of course, as usually. So don't worry about the quake.
So many famous professors. Sorry.
No. I would like, first of all, of course, thank you for our lectures. Are extremely interesting. It's a pity that it's a short time to everything discuss. I have a limit my questions. First is very simple. Where is the devil cave? Is in a sentence of the judgment or in justification, motivation? In Poland, this distinction is very visible, especially now in last case of our abortion problem, when the distance between sentence, which is just very short. This piece of act of statute is non-valid because it's in consistence with Constitution. Short sentence. And after 3 months, we have suddenly justification, 130 pages, where they explain this problem. What are consequences? What is a new interpretation? Well, in Poland, generally is a ban of interpretation of law. So this is a problem. Where is this lawmaking? Not in the sentence, in my opinion, but the main tool to lawmaking is motivation, is justification. First question. Second, very short, is a problem of so-called partitive control of position of constitution. It means that the ordinary, in Poland, ordinary common courts have a right to control the position of constitution in the case. So it's also, I think, a great field of activity, I think, possible activity for researcher. And I would like to propose this problem to treat it as a separate. And the third question, because I am from administrative court, I'm very interested in the constitutional control of self-government lawmaking, because it's a very important problem. In Poland, self-government has a lot of competence in lawmaking, and it's out of control of constitutional tribunal. This is competence of administrative courts, especially Supreme Administrative Court. So how to solve the problem of composition of these two so high courts and their activities in the control of this type of act of administration. Thank you very much. And again, my congratulations for everybody. Thank you.
Thank you very much, Professor Sadowski. And I would read just shortly the comment of Michal Andrej Krajewski, as I promised to you. So he would like to add to the discussion related to Ondrej Hanulak's question. If it is not possible, I'm citing, to constrain the Constitutional Court's activism by any theory of interpretation, does it make sense maybe to take seriously procedural measures to limit the power of Constitutional Courts, like deciding cases by qualified majorities, for example, or limiting the right to initiate proceedings in the abstract by Parliament members, rather than citizens in concrete cases, or even granting the Parliament the power to overrule the court. So these are further suggestions. And then I would really like to give the floor to Max and also to Jan Malir, Max Steuer and Jan Malir for reflection, and then to Monika to give the final comments on the comments of the audience. So please, Max, first.
Thank you very much. This has been extremely rich discussion, and I have no chance to respond to all the comments, but just let me mention that in response to Ondrej Hanulak and also Michal Krajewski, that I have some doubts that the constitutional courts in the end of the day are as strong, right? So they still do not have the power of the purse, nor the power of the sword. And we have seen also in this region examples of how easily, even through blatant unconstitutional measures, they can be overridden, for instance, through judicial appointments. And David Kosaj and Katarina Shipulova have an article on court curbing strategies that is very useful in this regard. So I would not be too worried about restricting the powers of constitutional courts, because ultimately, and there is literature, particularly from the United States, on judges and their audiences, for instance. Judges do need public support, or at least support from some expert constituencies, in order to be able to have impact. And so in that sense, if they are unable to provide justifications to those decisions, for instance, on overriding constitutional amendments, in Slovakia is an example, then they just cannot have impact with those decisions, and they are likely to face backlash. And this is also in a way the case in Slovakia. Just very briefly on the question of Professor Gabor on the precedents in the Slovak case, certainly there are also cases of inconsistencies that we can discover between the court deciding in a different way than it decided in a previous case on a similar manner, for instance, on the appointments of the president candidates and the constitutional court candidates. However, again, this goes then back to the question of justification, that the justification, if it is not present, and I think someone also mentioned, I think Professor Sadowski on the importance of the obiter dictum of the justification. If they cannot justify that shift, then they lose the persuasiveness of their judgment. And to the extent the precedent is about some sort of coherence, some sort of following previous ideas or justifying the departure from them, then they again may easily lose those audiences. And this has also happened in Slovakia, at least in one case. Thanks a lot.
Thank you. Jan Malir.
So as for me, there is obviously plenty of comments I would like to make in light of the previous discussion, but let's focus on just historical comments to our discussion when it comes to the border between interpretation and judicial legislation. It's probably interesting to point out that as early as in the 13th century, in Magna Glossa or Glossa Ordinaria, Accursio, Great Accursio of Bologna, mentioned that interpretation very often means to develop, modify, correct, or even annul the meaning of law. So apparently, it's, I would say, even anthropological constant element or inherent feature of Western legal systems, this tension between interpretation, pure interpretation, and legislation. Viewed from historical perspective, definitely there are instruments, legal instruments, how to tame the courts. These instruments normally work for some time, and later, due to evolution of social context, they turn out to be insufficient, or simply there is no will to use them. And in this regard, it's something which I learned from legal historians and legal anthropologists. They emphasize that we are taught to believe that legal evolution is linear, that we move towards higher and higher degrees, but in reality, at a closer look, upon closer inspection, this evolution is rather cyclical. So the periods of strong judges, of strong judge who interprets very, very far and who legislates are simply followed by periods when the people or the parliaments or other form of law creation come back. So actually, we have lived through the period of strong judges. Perhaps we are now at the beginning of a different period, but viewed from historical evolution of Western legal systems, that is nothing so new or so unique. And to finish, probably not to be sad or frustrated, lawyers are not the only to have this problem. I would say any human discipline which is linked to discussing words and their meaning faces these problems. So I tend to say that, for example, in any church, you are also confronted with the problems of this kind, whether it is the Pope who shall decide what religious rules are, whether it is the General Council of the Church, or whether it is the God who shall decide. So thank you very much.
Thank you very much. Monika, please.
Well, so maybe it will be not answers for the questions, but just I would like to react very, very shortly with concerns to 4 questions. Firstly, Frosina, I agree that it's not possible to make a distinction between the judicial lawmaking through interpretation and something which we call the activistic legal interpretation. So when it comes to this type of judicial lawmaking, maybe you are right. But, and this is the reaction to Andrei, question, judicial lawmaking can be made not only through the interpretation, but also through determining the legal consequences of constitutional court rulings. And if we ask about the boundaries of course, we can say that the boundaries for those two types of judicial lawmaking through interpretation and through determining the legal consequences of rulings are made by legal doctrine. But the problem is that, as we know, there are no control, in fact, of the lawmaking activity of the Constitutional Court. So that's why maybe the better question is not to ask about the boundaries of such kind of lawmaking activity, but about the the control, how to control this. As we know, it's not easy to control the interpretation of the Constitutional Court. And when it comes to the question of Professor Leszczyński, just very shortly, I see this connection, and it's true, the connection between the lawmaking activity and different types of interpretation, including this linguistic, systematic, and functional. And of course, this idea of the creative interpretation, legal interpretation, is connected with the question whether the Constitutional Court is bound by the results of the linguistic interpretation and how the other types of interpretation can be used. So it is, I agree that it is exactly the problem that we should tackle with when we talk about the judicial lawmaking. And when it comes to three questions of Professor Zirk-Sadowski, thank you very much for those questions. I think that I will, two of them I just analyze, and I will try to prepare maybe a paper or something like that just to answer. And but the first question, which was, I think, that the most important for our research is where is the lawmaking? Just in the justification, as Professor Zirk-Sadowski said, or also in the sentence. And I think that also in the sentence, I mean, the change formally is made on the basis of the sentence. I mean, the sentence is announced in the official gazette, and what is written in the sentence is the basis for the change of the law. But on the other hand, I think that justification is also important, and we can find also the lawmaking, the justification. This is connected with the interpretation, because as we know, the interpretation is not so often included into the sentence of the ruling. We have the examples of the interpretative rulings, but generally the interpretation of the Constitutional Court is included into the justification. So that's why I think that both the sentence and the justification are those parts of the rulings where we can find lawmaking elements. And maybe I will finish with this just to give more time for the rest.
I don't know. Are you sure you do not want to finish your thoughts? Because I think we might have some more minutes if you would like to finish.
I think that I think that some problems that were that appeared in the questions we come back in the second session. I think because they are common for the they are not the questions specific for the courts of the European, this part of Europe, but also for the Western courts. So that's why I think that we'll have time to discuss, and that's why I don't want just to to answer very general as I did, in fact.
In this case, I accept that we do not put an end note to the end of the sentence, but we will continue at 5 o'clock. So I just give the floor then to the next session that will continue the discussion at 5 o'clock today. So I hope that everyone can remain with us, and thank you for this very rich first session, for the presentations and also for the comments and this lively debate. And then I do not say goodbye, but let's meet at 5 o'clock and continue. Thank you very much.